Ms. Tracy, are you on the call as well?
Mr. Chairman?
Yes?
This is Dwight Gubrud. I'm attorney for the city of Belfough.
Okay.
We are present.
We're still waiting, I think, for one member to join the call, or one commissioner.
Okay, this is Alexis Tracy. I just joined. I don't know if that's who you're waiting for.
All right. I think that all the commissioners that we have are on the call. It's my understanding that Ms. Sovil from Sully County is not going to be available for the call, but we still have a quorum. So with that, I think we've reached the 9:30 hour, and I'd like to call the meeting to order. And Stephen, could you take a roll call?
Yes, Mr. Chair. Before I take that, I would like to remind everybody to mute their mics so we don't get a ton of feedback if they're not speaking. And also to identify themselves when they begin speaking, since this is a teleconference and we're not in person and can't see each other. And so with that, I'll take the roll call. Caitlin Hoffman.
Here.
Ms. Sovel's absent. Alexis Tracy.
Present.
Cassie Went.
Present.
And Mark Reedstrom.
Present.
You have a quorum, Mr. Chairman.
Thank you. I guess before we just get started here, I'd also kind of like to add to what what Steve indicated. If anybody's has a cell phone with them, I'd like that turned to vibrate so we're not interrupted during the meeting here. And those of you who are leaving the meeting, make sure that you disconnect. I've had situations before where somebody thought they were leaving the meeting, but may have dialed back into the meeting and contributed some information to the meeting that they perhaps didn't intend to. So just some of that discipline would be appreciated. We have a fairly full agenda, a number of items to go through this morning. I think we've discussed that we're just going to push through these until we get finished. Is that my understanding? Or were we planning to take a lunch break if it gets to that point? I think we should just push through.
I agree.
Okay. The first item on the agenda is the approval of the agenda. Do any commissioners have any additional items or items they wish deleted from the agenda? If not, I'd entertain a motion to approve the agenda.
This is Alexis. I would move to approve the agenda.
Do we have a second on that motion?
Second, Cassie Went.
Okay. And we'll do the voting by roll call, and I believe Steve has volunteered to do that, and we'll follow that procedure throughout the course of the meeting. We'll continue with roll call voting, except perhaps
the motion. Sorry, Mr. Chair. There's been a motion and second to approve the agenda. Ms. Hoffman?
Yes.
Ms. Tracy?
Yes.
Ms. Went?
Yes.
And Mr. Reedstrom?
Yes, the chair votes aye.
That's a unanimous approval of the agenda.
Okay, the next item on the agenda is the public comment period pursuant to SCCL 1-25-1. Do we have any members of the public that would want to make a comment at this point in time? And if you do, please identify yourself and make, prior to making any comment. Do we have any public comment? Hearing none, we will move to item 3 on the agenda. Approval of the minutes of the December 5, 2019 meeting. Have all the commissioners had the opportunity to review those minutes?
Yes.
Yes.
Do any of the commissioners have any amendments or additions or corrections to those minutes that they'd like to offer? Hearing none, then I'll ask for a motion for the approval of the minutes of the December 5, 2019 meeting.
Alexis, so moved.
Do we have a second?
Went, second.
Stephen, I'd ask for a roll.
Ms. Hoffman?
I guess I would abstain as I wasn't a member.
That's fair. Thank you for reminding me of that. Ms. Tracy?
Aye.
Ms. Went?
Aye.
Mr. Riedstrom?
Aye.
The motion passes.
Okay. We'll begin consideration of the pending complaints, beginning with in the matter of open meetings complaint 20-01, Board of Trustees for the City of Ward. There'll be 2 oral presentations. It's my understanding that Mr. Campman will be making the opening statement or presentation for the complainant. And who will be presenting on behalf of the Board of Trustees for the City of Ward?
This would be Steve Breitzman, Ernie and Brookings.
Okay. Since we've got a relatively full agenda, we're going to be scrupulous on keeping time. Each party has 15 minutes to make their presentation. A portion of that time may be reserved for rebuttal. Mr. Campman, wish to reserve any portion of the 15 minutes for rebuttal?
Were you asking me? This is Tom Cameron.
Yeah, Mr. Campman, are
Yeah,
you?
I'm gonna save some time for rebuttal.
Okay, how much?
At least 5 minutes.
Okay, I'll remind you after when 10 minutes has expired. And you may begin.
All right. They were looking for a bid for the snow removal, which they put a lot of stipulations in. And on the November 4th, in the paperwork, you'll see in the minute, they approved Scott to go talk to Elias and Renato about snow removal, which Scott was supposed to call, and he did. And then he was supposed to go meet with them. Well, when he decided to go meet, the whole form went out there without a public notice, without nothing. The city's clerk asked him, do we have to have a special meeting? No, We already discussed it with them, and we already settled it. So then I turn it in to Paul Lewis, the state's attorney, and he does nothing. So then I have to get a hold of the Attorney General, and I had to put a complaint in that Paul didn't follow through. Then we started out with the Sheriff's Department. Now, when the Sheriff's Department gets a request, you would think that they would ask more than one party. They talked to Scott, never talked to Renato, never talked to Elias. They both will, and they're very Christian people, will not lie, will tell you that they were awarded that contract. They live in Minnesota. They were awarded it on a Friday morning, on the 8th. The first meeting was on the 4th. Charity again asked them. The city's clerk asked them, do we need to have a special? Nope. The only two people that can clean snow in this town is Elias and Renato. And that's all in the emails that everybody should have in front of them. So then they go hire Steve Britzman from Brookings for attorney, because Corey can't represent them, because Corey had already talked to them before when they had a meeting, got pictures of them having a meeting, and said, hey, you guys can't be together. That's an open forum. You can't do that. You got to have it posted and all this. He had already talked to them before. So when they went to go do this, there was no way Corey Burning was going to represent them three. There's no way, because of the fact that he had already talked to him about it. And so, I mean, I've never seen an investigation where they only talked to one person. They didn't even talk to Renato, Elias, the ones that got the contract. Second off, this is the second time we've done it. So then I talked to Steve Blair, Assistant Attorney General, and he says, the Board Commission is not going to do anything anyhow. He said, all they're going to do is slap them on the hand. All they're going to do. And I said, well, if that's all they're going to do, then I got people from other towns that are going to start having meetings on Minnesota State side, and then come back and tell them what they're going to do. And this includes Sioux Falls. Just because we're a small town does not make it okay to do this stuff and just get slapped on the hand and not have to step down. I'm sorry, I don't agree with that. Because if this is okay for these guys to do it and get their hands slapped, then all of our township boards, our school boards, all our city officials, including Sioux Falls, because I have people from Sioux Falls that want to know how this turns out, because they say, well, we can get a form, go to the casino across the state line in Iowa, have the meeting. That way, when we get in front of the public, we already know how we're going to vote. We don't have to have the public input, which I agree. I mean, if, you know, like this, awarding the contract. So then they got in trouble, then they come back on the December meeting and said, yeah, now we approved the deal. They already approved it with Elias and Renato on November 8th or 7th, whatever that Friday was. So that was just a deal. But I guess if you guys want to just slap their hands, with Stephen Blair, the Attorney General told me that's what you guys do, then the rest of these, you guys are going to have a lot of complaints next year, because there's a lot of these boards that have called and talked to me, because this is in the Landry Enterprise paper and stuff, and they've all called me and asked me about it. And they said, well, we want to know how it turns out. So, and these three were warned by Corey Bruni, which is the city's attorney, about this. And there is pictures to prove that they were having a meeting. But that's why he did not represent them three. And why should our taxpayer pay their attorney fees, even Brett's attorney fees, when the city did nothing wrong? These three did it on their own. The city didn't do nothing wrong. Why should our taxpayer be paying their $700 some attorney fees, and now he's going to send another bill to the city for doing this meeting now? Why should the city have to pay them a fee? I guess them questions, and the rest of the time I'll listen to Steve, and then I'll rebuttal after his. I'm done. You can go on to Stephen.
You have about 9.5 minutes left for rebuttal.
I'll save it.
Is it, Mr. Brigham representing the city of Ward?
Yes, Steve Brightsman, if you can hear me all right.
Yeah, Steve Brightsman, and, you have 15 minutes to make your presentation.
Thank you. May I proceed?
Yes.
Thanks for the opportunity to appear before this Open Meetings Commission. I filed a detailed answer to the complaint, which I'll just try to touch on during my comments and try not to belabor some of those items, but it has been a few months since that was submitted. First thing I wanted to mention, I guess, offhand is that the city of Ward, I see that the census for 2010 indicates that there were 48 people residing in the city of Ward. So that would make the city of Ward a Class 3 municipality because it has less than 500 people. And fairly recent change in the open meetings law that I know everyone is aware of, but I see when I say fairly recent, in the last 10 years, the last full paragraph, 125.1, was added, and I think that is central to the city of Ward's position concerning this incident. And basically, just to kind of editorialize that section, it indicates if a quorum of township supervisors, road district trustees, or trustees for a municipality of a third class meet solely for the purpose of implementing previously publicly adopted policy, carrying out ministerial functions of the township, district, or municipality, or undertaking a factual investigation of conditions related to public safety, the meeting is not subject to the provisions of this chapter. And that particular section of the statute forms the basis for our position that the open meetings law was not violated. The city of Ward, of course, has a duty and the authorization under state law to regulate its public streets. And so 9-30-2 does provide that every municipality shall have the power to provide for the cleaning of same. And so snow removal, of course, is a widespread concern for every governmental entity in the state of South Dakota. And in this particular case, bids were advertised for snow removal services for the 2019-2020 winter, and no bids were received. And previous to that, they had snow removal performed by the party that's been mentioned in this case, Belfough, and yet no bids were received. And so the minutes of the November 4th, 2019 meeting indicates snow removal, no bids received. It was discussed if we cannot find anyone that everyone will have to do their own snow removal. Scott was instructed, and that would be Scott Hanberg, member of the Board of Trustees, was instructed to call Stoltzfus Farms to see if they were interested again. And the procedure for, under state law for advertising for bids does provide an exception, which provides that if after advertising for bids, no firm bids are received, the purchasing agency may negotiate a contract for the purchase of supplies, services, or public improvement projects at the most advantageous price if the specifications of the original bid are met. So we're under that type of circumstance. No bids were received after there was public advertising. And so if the city of Ward was a larger city, they might have a highway superintendent, or they might have a street superintendent who would attempt to locate a contractor to do the snow removal. And I did indicate in our answer that there was a impending snowstorm coming And so there was concern because there was no one that had submitted bids for snow removal. So Scott Handberg contacted this previous supplier of the snow removal, Belfough, and this individual who had done the snow removal requested that he come out because he wanted to talk to a board member. And because Scott Handberg, a member of the Ward Town Board, felt that there were complaints that the snow removal contractor had, that rather than repeating those, other township board members accompanied him to the farm to visit about snow removal problems. That did occur, and so there were more than a quorum of township board members at the farm to discuss the snow removal. But I would suggest that type of discussion was preliminary to entering into an agreement with Stolfus to address snow removal, and really was fulfilling the ministerial tasks that a highway superintendent would do if it were a larger city. That highway superintendent would have gone out there to visit with the contractor if that's what the contractor wanted. And so the visit to the farm was at the request of the snow removal contractor, and the three board members met with him to try to alleviate concerns and get that prior snow removal contractor to agree to provide the services. Again, the section of the law that provides or permits that to occur would be the last section of 125.1. And I think this situation is somewhat similar to the Open Meetings Commission decision related to the Culm Township Board of Supervisors, which was issued on November 3rd, 2017. And there simply was not a highway superintendent or a street superintendent employed by the city of Ward to attempt to get a snow removal contract. And so therefore, the board had to, or members of the board had to do that. And in order to convince them to submit or agree to provide snow removal services, they had to meet on his terms. So that meeting did occur, and then ultimately they asked him if he would provide snow removal in the interim before a contract could be approved, and he agreed to do that. One of the stipulations, I think, was that snow removal contractor did not want the public instructing him as to how the job was to be done. And so, that was one of the pieces of information that was gained in meeting with him. So that certainly helped to move toward having a contractor willing to do the job. Ultimately, in December, then the minutes of the Ward Town Board indicates snow removal. Scott had talked to Elias. I don't have a real clear page of the minutes, but it indicates that Scott Handberg, a board member, had talked to Elias, which I think was the snow removal contractor, and they wanted to meet. All three council members went out to Stoltz's farms and met with them. Reeves made a motion, second by Jorgensen, to approve a snow removal at $125 per hour. So the contract was entered into in an open meeting December 3rd, 2019. With respect to the section of the state law which provides for the exception, I think we're in a situation where the trustees of the municipality were carrying out a ministerial function, for one thing, because they were doing the job of soliciting or negotiating snow removal services on behalf of the city of Ward. And so the fact that all three were there would not constitute a violation of 125.1, because in order to get snow removal performed in the town of Ward, the contractor required that a board member meet with them, and so that all board members had adequate information, all three went to meet with that town board with that snow removal contractor. That somewhat indicates the urgency of the matter. But yet, snow removal and getting a snow removal contractor to provide the service was important to the city, and is certainly a ministerial function that normally would be performed by an employee if there was an employee on staff. In this case, the small town of Ward had to get that job done through the efforts of the board members. In addition, certainly snow removal and having no snow removal contractor in November, we do know that snowfall is certainly possible in November in South Dakota, and therefore these conditions of not having a snow removal contractor on board would relate to public safety as well, because I would think that the board members looked at this as if they needed to pull out all the stops to try to get a solution to the problem, and that's why they all accompanied Scott Hanberg to visit the farm of the snow removal contractor. I do believe that snow removal is a ministerial function, as well as lining up the snow removal contractor, and it relates to public safety. The contract was ultimately approved at a formal meeting, and in the interim, they were able to convince the snow removal contractor to come and do the job prior to receiving a contract. So for those reasons, I believe that we do satisfy the exceptions to the open meeting requirement. Quorum would need to publish notice and have the meeting open to the public. And that would conclude my remarks on behalf of the City of Ward.
Mr. Breitzman, you used 12 minutes, and so I would give you 3 minutes for final rebuttal. I have a couple of questions. Factually, I think it's undisputed that a quorum of this public body did meet with Elias and Renato Stoltzflip and discussed public business without obviously making that a public meeting or posting the proper agenda or providing the proper notice. So I'm focusing on the exception in 125.1 that talks about municipalities of the third class meeting for what they describe as 3 different purposes. And you've touched on 2, one carrying out a ministerial function, and 2, engaging in a factual investigation regarding conditions related to public safety. Is it your position that engaging in contractual negotiations with a contractor, which obviously would involve public funds, is a ministerial function of the municipality?
I believe it is. Briefly, I think that type of task in negotiating or hearing complaints from the vendor or the contractor would be duties that would be well within the purview of any municipal employee that was working in the function of either negotiating bids or attempting to solicit bids when none, or solicit services when no bids were received. So I think that type of activity would be the same as a highway superintendent would do under the same situation. And I think that all of those tasks would be ministerial and would not be discretionary acts that a city council or a township board of trustees would be normally engaged in. But because it's a third class city and there aren't employees to do that, they have to fulfill that ministerial task.
I'm not entirely convinced of that. I think it may be a little bit better argument for the city of Ward to maintain that they were in this form of the board was undertaking a factual investigation of conditions relating to public safety. That factual investigation being, can we convince this contractor to accept this contract and under what terms, in the absence of any other bids, having been received. What would you like to expand on that?
Well, I would agree. I think that it's hard to imagine a city not having any kind of plan for snow removal in November, and therefore this is an unusual circumstance. Just because normally the snow removal contractor probably wouldn't exert such leverage over a town to require that they go to his farm to talk over concerns about providing that service. Certainly, snow removal falls clearly within the public safety area, I would say, and I don't think that there's probably too much argument about that point. But the fact that they had to go out there under these unusual circumstances would, I think, qualify as a factual investigation because they needed to hear, what were the reasons why this contractor who had done the work before wasn't willing to do the work again. And while the job could have been done by one of the township board members, and they could have related that information to the other board members, it's probably not that much unlike, really needing to do a couple of things. Number one, observe or listen exactly or from the contractor to find out exactly what the concerns were so that there wasn't misunderstanding. And then the urgency there was certainly there in November without snow removal services. So similar to going out to look at a culvert where the township board members would look at the exact conditions. Here, I think hearing complaints about how the public treated the snow removal contractor certainly was a factual investigation, not dissimilar to looking at conditions of a street or a culvert or something like that.
It certainly didn't require all three to go out to have that meeting. I mean, Scott could have done it on his own and come back with, those reasons and his investigation. Probably would have been better. It might not make any difference because of this exception that you've argued.
I would agree. I think that I would agree with that point that whether those elected officials felt that one or three of them should attend might be an error in judgment as to all three. Certainly, it did, obviously raise concerns having a quorum of 3 at that location, because they're obviously relying on the exception to the statute, and we certainly wouldn't advise them to do that. And I know they won't do that in the future, but nonetheless, I would agree with that point.
I don't have any further questions from the chair. Do any of the other commissioners have any questions that they'd like to ask Mr. Breitzman?
Yes, Mr. Chair, this is Alexis Tracy. So it's being asserted that there was an imminent projected snowfall, is that correct?
That's my understanding. Yes.
And do you know if, so that was projected to happen before the next meeting of the board then?
Correct. And I believe it was, we did check what the weather, I wasn't involved, of course, at that time, but it did indicate that that's what prompted the concern to address it before the next council meeting in December.
Thank you. And then because of the exception regarding the public safety aspect of things, and I think that is probably the more appropriate potential exception rather than the ministerial functions, because I'm not certain that I am tracking you with that. I think by that argument and rationale, all functions of a public body can be viewed as ministerial. So I think that the public safety inquiries are more appropriate, but for future reference, it would be perhaps a more prudent thing to do to invite the contractor to come to the meeting. Would you agree with that?
I certainly would. Yes.
And then, you know, if that wasn't the case, perhaps just publish notice of a special meeting if they are going with a quorum to him.
Agreed.
I have no further questions.
Any further questions from any of the other commission members? With that, we'll turn back to Mr. Campman. Are you there?
Yes, I am.
You have 9 minutes and 30 seconds for rebuttal.
All right. First off, there's never been a contract with anybody for snow removal. Get that off the table right now. Second off, they started advertising for snow removal in September because the 3 board members are the only ones that had problems with Stofus doing the snow. So they made all these exceptions. Oh, you got to haul the snow out. You got to do this. You got to do that, because they did not want Stofus doing the snow removal. Well, you don't get anybody to come into a town of 35 people to remove snow. So then they went out and talked to Paul Bartel, which he said, I ain't got the time to do it. So then they re-advertised for bids again, took out that they didn't have to haul the snow out. Still nobody did. So now they messed around for 2 months trying to get snow removal until it got down to where I, as a business owner, said, if you guys don't want to remove the snow, I'll remove it my own to keep my business open. I collect sales tax for the state of South Dakota. I got to have parking out on the street. That's the way it is. I told them I was going to charge them $125 an hour. And that's when they got all bent out and said, we ain't paying nobody $125 an hour. And I said, you guys can't get Paul to do it. You put so many stipulations on this that nobody will bid it. That's when they decided to send Scott out to talk to them. I got to be open. And I got my own snow removal stuff. I can remove my own snow. And the neighbor, he's got a business too. He can remove his own snow. The only ones that were bitching about the snow removal the prior year was the city council members, because they had too much snow pushed up in their yard. And if anybody remembers the snow of that winter, the year before, we had a lot of snow. Where are you going to go with it? You know, that's just the way it is. But Paul Bartel can also tell you they come out and begged him to come in and do it. And they wouldn't do it. And as far as the forum, they do this stuff all the time. They've been caught twice. And then you guys want to have these stipulations that if you're under 500 people, they can do this all the time. Well, then there's no sense having a city council, because they're going to do it all the time now. They're going to go meet in somebody's house and predict it. These three members, the only ordinances that have to be observed are by the rest of the city, not them three. They don't have to follow ordinances. And that's the truth. You can talk to anybody in this town, and they'll tell you that. But, I can see Steve's point. If they got this little glitch in the law that says that they can go over there out of state, then the rest of these guys are going to start doing it, and they're going to use this as an example, because it shouldn't matter how big your town is. You shouldn't have a forum outside of the state of South Dakota. And Elias and them, the only reason they didn't put a bid in was because the three council members constantly bitched about the way he was moving the snow the year before. That's why he didn't, and you guys can call him, and he will tell you the honest truth. That's why he wanted to meet with them face to face. And I guess if they can still stay on the city council after all this, and the city has to keep paying Steve to represent them, I'm done collecting sales tax for the state of South Dakota. That's the way I feel. We shouldn't. The only reason this town is even alive is because of the 2% that I collect. Because this town was flat broke 17 years ago. Flat broke. Couldn't even buy a load of gravel. Now the checkbook's over $150,000. Now they spend money like it's candy because they got the money to spend. They don't care. They do something for the city. They charge the city. They can paint the lines on the sidewalk. They charge the city for doing it. I mean, you're a public servant. You're supposed to help the town out. You're supposed to make things better, not these three. And I rest my case. I'm tired of them three screwing the city's tax dollars away and giving it away and doing these forms on the side. They're still doing it to this day. That's all I got to say.
Thank you, Mr. Campman. This is Mark Riedstrom, the chair. Mr. Campman, I hear your concerns, and I just want to say that this board has a responsibility to determine whether or not open meeting violations have occurred. And if we find a violation has occurred, our jurisdiction is limited to issuing a reprimand. That's all we can do. That's the most we can do. We can't right wrongs. We can't make decisions that are outside of those parameters. What I'm interested in Mr. Campman, is the argument's been made by the city of Ward that the meeting that took place in Minnesota, and I don't believe that that's any kind of a distinguishing factor here. I don't believe going out of state circumvents the open meeting laws in any fashion. But the argument's been made that this meeting that was held is not subject to the provisions of the open meeting laws because these three council members were carrying out either a ministerial function or they were undertaking a factual investigation relating to conditions relating to public safety. I want you to, and I think that's the focus or the crux of what we're needing to decide here. So I'd like you to just spend a minute or two addressing those two issues. What's your position as to whether they were carrying out a ministerial function or they were undertaking a factual investigation related to public safety?
Well, first off, Elias and Renato would have never moved that snow because them three had to go out there and kiss his butt to get us to do it. That's the bare facts. You can ask them if you want to. As far as safety concerned, there's no safety concern because the street coming through town is plowed by the county. If you got to get out, you got to get out. I mean, myself and the neighbor here that has the repair shop, we've moved snow, we've pulled buses out, we've done everything. There's no safety factor involved in this. I mean, if it's a tornado, that's a safety factor. Snow, if you haven't lived in South Dakota long enough to know that you're going to have to scoop snow, then you better move to Arizona. That's the way I think about the safety factor of snow. That's the way I see it.
You would disagree that snow removal within the city isn't a condition related to public safety as a matter of course?
Nope, they don't even, I mean, we only got one block one way and one block the other way. I mean, I've seen EMTs and everything carry patients a quarter of a mile in snowstorms because my grandma had it done. There's no safety concern. When you can get to a house within a block, you can walk it if you have to on a safety concern. So snow is not a safety on a one block walk. I'm sorry. I've seen it a half mile walked by EMTs and ambulance crews. And I mean, we're only one block off the main drag. I said, that's all we got. 330 feet is the furthest you'd have to walk. You know? I call that a safety concern. You better not go out and get your meal. You know?
All right. Do any of the other members, commission members, have any questions for Mr. Campman?
Yes, this is Alexis Tracy again. Thank you, Mr. Chair. Mr. Campman, do you dispute that there was an imminent snowstorm coming?
I don't know if you want to call it a snowstorm. We got some snow.
Okay, and then
I guess I've lived in South Dakota long enough. I ain't seen a good 3 or 4 day blizzard in so long it's unreal because we get people through here all the time. And we never did get a big snowstorm.
And then is your primary question or inquiry that this decision was not made at the November 4th meeting?
What do you mean? The November 4th meeting said that they were supposed to send Scott out to meet with or talk to Elias and see what he comes up with. It didn't have nothing to say about a warden telling them to do it. There's never been a contract. The city of Ward has never contracted with Paul Bartel. He did it for 20 years. Elias has done it now for 2. There's no contract. It's just a word of mouth that says, hey, will you do it for this? And that's all they do.
So had that discussion been had at the November 4th meeting with the individual they ultimately went with for snow removal, you would agree that that would not have been a violation, correct?
That's right. If they would have had him come into the meeting, they could have called him at the meeting that night. But the three board members are the ones that were complaining to him, and he wanted to confront them face to face because they're the ones that complained. They were even out videotaping them with their phones.
So had Mr. Scott just gone out and visited, and then the meeting was held on December 3rd to ratify and discuss it further and make that decision, you wouldn't have a problem with them having gone with this other snow removal service instead of you, correct?
I wouldn't have had a problem if he would have come back on Friday and said, let's have a special meeting on Monday night. I wouldn't have had a problem to pay him to have a special meeting. You know, they have a special meeting all the time when they get a little short on cash, you know, so they've had... I just wanted to clarify because it sounds like your concern is that they went with this other company instead of you rather than how the decision was made. No. What I'm concerned about is they went and did it. They went out of the state line. They've been warned before by Corey Bruning, the city's attorney. There's pictures of them having a forum. Corey Bruning talked to them and says, you guys can't do that without having it posted as a special meeting. So they still go out and have this meeting out at Sophus and no posting, no nothing. They award him to tell him to go ahead and do it and don't let anybody else touch the snow without even talking to anybody in the public or even having a meeting. Why would you do that? I mean, it's our tax dollars. It's our tax dollars that they're spending. And it's like they got an open checkbook. They just write the check, let's go. Next one, you know?
Okay, so I just to come full circle then to the public safety argument, I respectfully disagree with you about whether or not snow removal is a public safety concern. So going on the premise that it is a public safety concern, based upon your understanding of this meeting and what happened, would you agree that they were inquiring about how they could get snow removal accomplished for the city of Ward and why there was concerns or problems in the past?
No. I think they started it in September. I don't know if you heard that whole story, but they started it in September. They were doing anything and everything they could not to have Elias and Renato move the snow because of the fact they didn't like the way you moved it the year before when we had record amount of snow. And I mean, so
you would agree that there was some factual inquiry into snow removal?
Factual inquiry?
Factual inquiry into the manner in which the snow was removed.
Yeah, they were having complaints. They complained. Nobody else complained, just them three board members.
Okay, so you would agree that there was a factual inquiry into snow removal?
Yep. And they had.
I have no further questions.
Okay.
Do any other commission members have any questions of Mr. Campman? Okay, hearing none, then Mr. Brightsman, I believe that you have 3 minutes remaining for any rebuttal that you may wish to take.
Thank you. I'll just take 1 minute, I guess, just to summarize. I think that access to a residence is important, and hiring EMTs, first responders to or difficult to access a home in an emergency certainly is a public safety concern. Snow needs to be removed so you can have reasonable access to the residents, it would seem to me. And then the second thing it would be that was 3 board members to go out and try to convince this party to provide or submit a proposal to do snow removal. Certainly, he wanted to express terms and conditions. The contractor was willing to do that job, and I think that does constitute a factual investigation to hear what his complaints are, because he hadn't submitted a bid, so it was an uphill battle to convince him to submit a bid, and that required investigation of what the reasons were so that those could be addressed. I think that falls within that exception. Be my comments at this point.
Okay, I think that will conclude, this is Chairman Riedstrom, that will conclude the oral presentation portion of this complaint, and with that, I think we'll move to deliberations on this. I'd open it to the members of the board to share your comments and your opinions or your conclusions regarding the alleged violation.
This is Alexis Tracy again.
Okay.
Okay.
Go ahead.
I think that probably from my questions, the rest of the board can gather that I'm in agreement that I think this probably is a very narrow exception on this particular occasion, I think that the board or the city of Ward should certainly be cautioned, because absent this exception of a third-class municipality, I think this would be a violation, pretty clearly regarding contractual negotiations and a quorum. I think it's irrelevant that it happened outside the state. I think there was a quorum, discussions and decisions were to be made. However, because I think that there was a factual investigation, like Mr. Chair, you were indicating, and like the attorney for the city of Ward was indicating, into why the bid wasn't made, and it absolutely involves public safety. I don't care how far away that is or what type of a stretch it is. There could be elderly individuals, there could be emergency services that need to be rendered. Snow removal is a public safety concern, especially with imminent snowfall. So for those reasons, I lean towards it being an exception under that factual investigation into the conditions of public safety.
This is Chairman Riedstrom. I'm of the same mind here. I think that if it wasn't for this relatively newly adopted provision in 125.1, I think that this would be open and shut. It would be a clear violation. But I think into that narrow exception about conducting an investigation action of conditions related to public safety. And it doesn't much matter to me whether there was an imminent snowfall event coming. I think that snow removal is just by in and of itself related to public safety. Here we are, November, have yet to get a snow removal contract. They needed to figure out why we're unwilling to take the contract again, and that's what they did. So I think that it falls within that exception, and the meeting that took place is not subject to the provisions of 125.1.
This is Cassie Wendt. And I would agree with what has been set out by Ms. Tracy and Mr. Riedstrom. In addition, I think it's important to note that the township started to look for bids in September, because I think that also gives credence to the public safety emergency that they were in come November. If they had started in November, the 1st of November, to get those bids, it could be a different story. But we're talking about starting in September and spending that time to try to get bids and to try to get something in place before the snowfall. So I think that, and I agree that snowfall is a public safety concern. I mean, it's definitely something that must be addressed in order to keep our city safe. And for all of the other reasons stated by Mr. Riedstrom and Ms. Tracy, I agree that this was outside of the open meetings and falls within the exception.
All right, do we have any other comments? Anybody else?
Kate Hoffman. I was just going to add a few comments. Particular to Ms. Tracy's line of questioning with the complainant, I guess I would just piggyback. I'm in agreement with what has been said as well, coupled with the fact that there was an admission that he agreed, Mr. Catman did, that there was a factual inquiry about the snow removal.
I would, this is Chairman Riedstrom. I would entertain a motion at this time.
I would move that there was no, this is Alexis Tracy, I'm sorry. I would move that there was no violation pursuant to the public safety exception.
Do we have a second on that motion?
Cassie went second.
Second, Kate.
Okay, we have a motion and a second. Mr. Blair, could you take the roll call?
Ms. Hoffman?
Aye.
Ms. Tracy?
Aye.
Ms. Wendt?
Aye.
Mr. Riedstrom?
Chairman votes aye.
It's unanimous. The motion passed.
That would conclude proceedings in the matter of the open meetings complaint 20-01 Board of Trustees for the City of Ward. We'll move now to item 4B on the agenda in the matter of open meetings complaint 20-02 Belfough City Council. I understand that the complainant that will be presenting on behalf of the complainant is Mark Watson. Who will be presenting on behalf of the city of Belfough?
Dwight Gubrud, the city attorney for the city of Belfough.
Each side has 15 minutes, and which will begin with Mr. Watson, and your time starts now.
Mr. Riedstrom, may I, just a moment? This is Cassie Wendt.
Yes.
I would like to recuse myself from the hearing and voting on this matter. As you will see from the information provided, it was my deputy state's attorney who conducted the investigation into this matter. I think it's appropriate for me to be involved.
And that's clicking you. We still have a quorum. And Mr. Watson, are you there?
I am, yes. Everyone hear me okay?
Okay, Mr. Watson, you have 15 minutes for your oral presentation. Go ahead.
My name is Mark Watson. I'm the managing editor at the Black Hills Pioneer. On December 2009, Belfough Council regularly actual safety matters, citing 152, Section 4, and Section 6. On its return to regular session, the council voted to declare the Belfough Area Community Center HVAC system in need of emergency repairs for public safety system.
Mr. Chairman, Mr. Watson, I apologize.
Yeah, I'm having a really hard time hearing.
Yeah. Getting a lot of feedback and almost sounds like road noise. So if everybody could mute their microphones. Mr. Watson, are you there?
I am, yes. Can everyone hear me okay now?
Yes.
Yes.
Start over?
Yes, go ahead.
Okay. Mark Watt, I'm the managing editor of Black Hills Pioneer. On December scheduled meeting. During this meeting, executive session, factual section 6. The board was in executive one half voted area community center HVAC system in need of emergency repairs for public health and public safety to the premature failure of
This is Alexis Tracy. I'm still having trouble understanding what is being said. It keeps cutting out.
I'll take it off as speaker in case this is any better.
Yeah, I think it is better.
Okay, I apologize about that. So at the meeting, our reporter, who typically covers Belfough, was not there that evening. However, she did watch the video of the meeting that the city posted onto its website. In the days following the meeting, Lacey reached out to Mayor Gloria Lamphere, the city attorney, and one of the council members, James Egger. James told Lacey through a text message later that contractual negotiations did not occur during that executive session. Also, he said he did not feel that executive session was necessary. Lacey visited with the mayor after another council meeting about the executive session, and the mayor told her that anything related to contracts goes into executive session. The city's finance officer and the city engineer also met with Lacey and the mayor at that meeting. They brought up the public safety issue as a justification for executive session. After Lacey and I discussed the conversations she had with Belfough city leaders and staff, we felt the city interpreted the closed session exemptions too broadly, and we chose to file the open meetings complaint. 125.2 Section 4 allows the city to go into closed session to prepare for contract negotiations or negotiating with employees or employee representatives. However, we are told no contract negotiations were held. 125.2 Section 6 references 127, 1.5, Section 8, and Section 17 regarding public safety. Section 8 lists a number of exemptions from the public records, including response plans, emergency management or response schedules, public safety information that would create a substantial likelihood of endangering public safety or property if disclosed, and more. Section 17 exempts the public disclosure of response plans, locations of sensitive items, and safety reviews. While we agree the Hvac system of the community center did need to be replaced, and probably in an emergent manner, we do not believe that this was a necessary reason to enter executive session. Actually, emergency repair authorization was approved immediately following that executive session in open session, and the issues about the Hvac system were widely known around Belfough. We do not believe that the city moved into executive session with malice, but we also feel that the city is too liberal in its use of executive session. As part of our duties holding local governments accountable, we chose to file the open meetings complaint. Does the board have any questions of me?
This is Chairman Riedstrom. I don't have any questions. Mr. Watson, did you want to reserve any of your time for rebuttal?
Yes, if I could. 5 minutes should do it.
Right. Do any of the other commission members, commissioners, have any questions for Mr. Watson? Okay, with that, we'll move to the respondent. And
Yes, Chairman Riedstrom?
Yes?
Can you hear me?
Yes, I can.
Okay, this is Dwight Gupta. I'm attorney for the city of Belfough. And I guess start off with, I'm attorney for the city of Belfough. My partner, Kellen Willard, prepared the written response for the city. However, he is currently deployed in Africa with the Army National Guard. So I have picked up the laboring oar to respond to this complaint at this meeting. And there's a few things that I think have been overlooked and left out of the inquiry that was sent to the commission that I think it would be helpful for the commission members to know. The city of Belfough owns and operates a large community center that's popularly referred to locally here as the rec center, and that is the facility that is referenced within the inquiry or within the complaint. This building is a very large building. It contains a theater that seats over 400 people, a gymnasium, has meeting rooms, racquetball courts. It's got a weight training room, a cardio fitness room. It's got a large indoor swimming pool, water slide. It's a multi-million-dollar facility. But what is very important about this facility is it is also declared to be the designated emergency shelter for the city and the Butte County Office of Emergency Services. It is available for use by the public for storms, tornadoes, floods, power outages, natural disasters, civil emergencies, and pandemics. So it is a critical facility located in the city of Belfough for the public's health and safety. And as you can see, if you look at, I believe it's marked Exhibit 7 from the information that was provided to the commission. Exhibit 7 is a copy of a letter from Rasmussen Mechanical Services. Rasmussen is a contractor that the city has used to maintain the heating, ventilation, and air conditioning system within this facility. It is very important for the commission members to review Exhibit 7. But I want you to note that Exhibit 7, that letter from Rasmussen, is dated December 14th of 2019. And all of you live in South Dakota, so you know what the weather can be like in December and January and February. The letter that I'm referring to, which is Exhibit 7, notifies the City Council that the HVAC system at the rec center is failing, that its system is creating a condition that's in the letter called extremely dangerous for the people in the building, and it's extremely hard on the equipment and the building itself. In that letter, the contractor notifies the City Council that the current condition of this system constitutes an urgent public health threat, that there is the potential for a bursting hot water system that would be a catastrophic event that would not only damage the building but could injure people within the building. 2 days later, City Council held its regular council meeting. By the time of this meeting, the council members had not had an opportunity to meet or had a chance to discuss the problems or the potential liabilities caused by this situation. That night, the council adjourned into executive session with legal counsel. Now, I'm not at liberty to discuss exactly what was discussed during that meeting, but you all can imagine, and I think you all as attorneys know of an employer's obligation to provide a safe environment for its employees. This could have been an issue discussed. You also know of the public of the obligations of a public accommodation to provide for the safety of its guests and patrons. You also know of the liability that arises when a known threat is ignored or disregarded. Those issues could very well have been discussed. In this case, executive session is clearly authorized under South Dakota law. As Mr. Watson mentioned, SDCL 1-25-6 allows for executive sessions for purposes of discussing information listed in those subdivisions of 1-27-1.5, subsection 8, and subsection 7. Exhibit E of the city's response is a copy of 1-27-1.5. And to start off with, look at paragraph or subparagraph 8. And remember, this facility is an emergency shelter available for use by the County Office of Emergency Services. The state law allows the council to meet in executive session under Section 6 to discuss whether this situation should be considered an emergency and how to respond or plan for the emergency. This clearly falls under subsection 8, and I'm sorry to read, but we need to look at the language used in this statute very carefully. Subsection 8 specifically allows for executive session to discuss, quote, information pertaining to the protection of public or private property and any person on or within public or private. We can stop right there. Has the City Council met in executive session to discuss information pertaining to the protection of public property? Or has it met in executive session to discuss information pertaining to protection of any person with public property? Number one, I don't know how you could ever read this statute and read the letter marked Exhibit 7 and not conclude that the meeting in executive session to protect public property or to protect people with that public property. Subsection 8 goes on. You can discuss that information, including, if we jump to subsection B, for discussing an emergency management or response. If you look at Exhibit 7, the letter from the contractor that talks about an urgent public health threat, I think Council is clearly able to meet in executive session to determine how it to respond to this emergency and how it plans to manage the emergency. So I think subsection E also applies. And then if you jump to subsection G, as in, I don't know, Gubroot. Subsection G allows for discussion of any infrastructure record regarding any building or facility that would expose or create vulnerability through disclosure of to security of critical systems of the building. The letter from the contractor that maintains this HVA system constitutes an infrastructure record under subsection G. And I think the Council is able to meet in executive to this infrastructure record because it specifically talks about the security of a critical infrastructure system, and that is the HVA system for an emergency shelter. Under the circumstances for the Commission, executive session to discuss a potential catastrophic failure of this critical system, which is that system is currently urgent public health threat, clearly qualifies for the Council to meet in executive session under SDCL 1-25-2. Thank you, and I reserve the remainder of my time for rebuttal.
Okay. Any questions from the commissioners?
This is Alexis Tracy. I do have just a couple of questions. So you would say that this is confined to, would you agree that there is, that contractual matters were not discussed?
I can't agree or disagree what was discussed. I know that contractual matters was cited, and I think that subsection was probably because it's possible that the Council have decided that it may wanted to negotiate some resolution of this situation, but I think our strongest defense is subsection 6, which discusses protection of public property, protection of people within public property, and emergency responses, and infrastructure record.
So that's what you would confine your argument to, is the subsection 6 instead of the subsection 4?
Well, Commissioner Tracy, I'm not ready to abandon the contract negotiation provision, but I think it's so clear that subsection 6 qualifies that I'm trying to hit the high points here. without having to divulge what was discussed in executive session.
Sure, and I don't want you to necessarily have to get into specifics, but since contract negotiation was cited in the minutes, I'm just wondering if addressing the public safety concerns through some type of negotiation for remedying that with a local company or something would also be applicable.
Well, I think the council may have discussed or could have clearly, it would have been within their right to prepare for contract negotiations, because there may have been alternatives that could have been discussed, how to address the urgent failure of the system. I think that the executive session is permitted under subsection 4, but subsection 6 to me seems so clear that they are discussing how to protect the public property and the people within that public property. That's a stronger argument.
If I could just, this is Chairman Riedstrom, if I could just jump in here quick. I don't think subsection 4, preparing for contract negotiations, applies whatsoever. That exception was the subject of a prior Open Meetings Commission decision in South Dakota Science and Technology Authority's case, and it was interpreted to be not conjunctive, but the two clauses read together. And subsection 4 is basically been interpreted by the Open Meetings Commission as preparing for contract negotiations about employees or employee representatives. The two have to be read together. As former Commissioner Steele had stated in his opinion on that case, if executive session were permissible generally to discuss contractual matters, it would open an exception or a hole in the open meeting laws that you could drive a bus through, because almost anything can be deemed to be a contractual negotiation or whatever. So I don't believe that exception applies. I think our focus needs to be whether or not this was an emergency management response or public safety information that would create a substantial likelihood of endangering public safety or property if disclosed. I have no argument with the fact that there did exist an emergency kind of a public safety and property issue that needed action. The issue is whether that should have been discussed in public section or executive session. So it's not so much, in my mind, whether an emergency situation or emergency public safety situation existed. The issue is more whether or not the disclosure of that information to the public would create the danger of, or create the likelihood of endangering, the public or public safety or property. And I can't see how discussing an emergency contract for repairs, the disclosure of that, I don't think that creates the release of that information. I don't believe that creates a danger to public safety or property. So my question is, how does disclosing that information, what was said during executive session, if that were public, why would that be dangerous to the public? In my mind, public would be less in danger if they had that information and they knew about it, which they could have if it would have been in public session. Do you understand the gist of my question?
Yeah, Chairman Riedstrom, first off, the letter doesn't discuss a contract. The letter marked Exhibit 7 from the contractor informs the council of the dangerous conditions present, need to address those conditions. Second, her statement has that there must be some showing that disclosure of the public would somehow make them vulnerable. That is not a standard set forth in the statute. SDCL 1-27 1.5 allows for discussion of information pertaining to protection of the public or protect persons within the public property. There's nothing in that statute that says that release of that information to the public would have to somehow be dangerous or render some vulnerability. That is, under Section G, something that should be considered, but there are other sections that this executive session is authorized under. And I'll fully admit that under Section G, when reviewing infrastructure records, there should be consideration over exposure or creating a vulnerability through the disclosure of the location, configuration, of security of critical systems. But that's only one section. That vulnerability language does not apply to the opening sentence of subsection 8 or subsection 8B.
This is Alexis Tracy again. Wouldn't it apply to 127 1.5 subsection 8C?
Yes, and we've not offered subsection C as a justification for the executive session. The opening paragraph, if you read the law, says we have a right to meet, a city has a right to meet an executive session to discuss information pertaining to the protection of public property or any person within public property. And then it goes on to say you could also discuss all of the items in subsections A through G.
Oh, but the plain language of the statute says including, and it goes on to qualify public safety information that would create a substantial likelihood of endangering public safety or property if disclosed. So isn't it by virtue of the fact of qualifying if disclosed that the legislature is providing further definition for the protection of public or private property or any person or the public?
Well, maybe you can't, maybe my voice isn't clear. I would agree for subsection C as in cat, that is listed, but we haven't even relied on subsection C. We're relying on subsection B as in boy, which allows for, in addition to discussing information to protect the public, you can discuss emergency management or response. So how are you going to respond or manage this emergency is one thing that can be discussed. There's nothing within subsection B as in boy that requires any showing that sharing that information would endanger the public if disclosed.
How has the condition affected emergency response then? How has it affected emergency management or response?
Well, the council has the right to discuss, number one, how are they, information, like a letter from the contractor, they have a right to discuss in executive session. The letter, which constitutes information regarding protection of the public property and people within the public property. Subpart of that would be section B. This is an emergency. How do we want to respond to this emergency? How do we want to manage this emergency? This isn't, I think the confusion here is I sense you're thinking that we are somehow discussing a plan that's in existence prior to an emergency, but at the time the council met, they had an emergency before them, and under subsection B, they have a right to discuss how are we going to respond to this current emergency or how are we going to manage the current emergency, and subsection B authorizes that discussion to occur in executive session. That's the plain reading of the language.
When I think emergency, I think, natural disaster, pandemic, those types of things. I'm not certain I'm tracking with you on that. I could see if this were articulated to go into executive session to discuss liability purposes and things of that nature for, potential litigation, potentially being sued or something in that regard. But I'm just not quite certain I'm tracking with the emergency management or response.
Well, then I asked the commission members to read Exhibit 7 because in that letter, the contractor talks about this, quote, this is an extremely dangerous condition for the people in the building and is extremely hard on the equipment in the building and the building itself. He later writes, this is an urgent public health threat that must be addressed very soon. He talks about the danger of a bursting hot water system. This talks about a catastrophic event that this would be. So I think there's clearly a public health threat by the condition of the system itself. How can the council not be entitled to, if the law allows them to meet in executive session to discuss, quote, information pertaining to the protection of public property and any person within public property? If that's what the law says, how can this situation not be considered appropriate for executive session in light of the contractor's very alarming warnings?
Do any of the other commission members have any further questions? This is Commissioner Riedstrom. All right, then. Let's move back to Mark Watson. You have 5 minutes for rebuttal.
Thank you. So, with Mr. Goodbrood's argument about Section 8 of 127, 1.5, the first sentence is a very broad description. I think when we looked at the examples A through G, we took it more as an intent and a meaning behind the exemptions. You could argue that the city council could, based on that first sentence, go into executive session to discuss the expansion or contraction of the police department or the fire department. When we look at those A through G items, it was more strategic exemptions. An emergency cites section Bravo, emergency management. I would interpret that more of a strategic plan to how are we going to stop the riots in the street that some cities are seeing. A lot of the A through G items is common sense information. Yeah, we shouldn't disclose lot combinations or when the guard schedules are going on, and having blueprints out there to show the public exactly how all the facilities are laid out. That quite probably is a good idea to have just to the local government, but it's common sense measures. We have no argument. Go ahead,
Mr. Watson. This is Mark Riedstrom. What's your argument on subsection G of subsection 8 regarding blueprint, building plan, infrastructure record? As it relates to Exhibit 7.
Sure. The letter was submitted to the council. I don't know if that was included in the packet. Quite often, items like this is included in the packet that is made public. I don't know if that was or was not at this time. But would it have created a vulnerability through the disclosure of it? It was widely known throughout Belfough that the HVAC system and heating system was failing. The boiler failed the year before. There'd be a really easy way to make it more secure, and that would be to close the rec center to the public. That never happened.
You still have 1 minute left if you want to use that.
Thank you. I guess overall, interpreting Section 8 along with items A through G, it narrows the scope to more of a strategic and protecting facilities from malicious people going out to attack vulnerabilities of facilities. And that is my argument.
All right. Very good. All right. Any rebuttal?
Very briefly, Chairman Reedstrom. Mr. Watson points out that, they could have closed the rec center when he was discussing subsection G. That could have been one of the options that the council wanted to discuss. What would be the pros or cons of closing the only emergency shelter designated in Belfough? They could have discussed whether or not they should simply repair the existing system or what the likelihood of repairs would be. However, of course, in December, repeating a heating system for a multi-million-dollar building with a large swimming pool might not be a good choice, because if it fails in the deep cold of January and February, it could create an even bigger problem. Or they could have discussed replacing it. The council had a lot of options to consider with an emergent situation, and I submit, acknowledging to the public that there is this dangerous condition in an emergency facility, I think discloses that there's a vulnerability there. I don't know what kind of unforeseen problems could have arisen or what kind of security threats that could present, but I think this statute authorizes those discussions. And more importantly, the discussion that is likely to have occurred is to review the information that they received and figure out a plan to deal with this emergency to protect public property, protect people within that public property. So I would urge the commission to find that there has not been a violation of the open meeting laws. I think the statutes as written clearly allow for a meeting to consider the information shown in Exhibit 7, and I'd encourage the commission members to review that letter closely, because there are some serious conditions disclosed in this. When you've got a contractor telling you that it's an urgent public health threat and that it's an extremely dangerous condition for the people within the building, I don't know how it could be any clearer that this information can be reviewed in executive session, because it's information pertaining to the protection of the public and public property. Thank you.
Thank you. I think that concludes the oral presentation section of this hearing. I think that we'll move then to in deliberations. Anyone care to begin? Anybody have any comments Any deliberation discussions? This is
Alex. Go ahead.
Go ahead, Lex. We always seem to start jumping in together.
Yes. So, in reviewing things, I see where that subsection 4 is clearly unapplicable. So I think we are just down to the subsection 6 of 125.2, whether that applies. When I think of emergency management, I think of our emergency management department, and I think of their response to specific events and discussion and coordination with the commission on how best to go about that from a public safety standpoint. So I'm struggling a little bit in making that jump here, given the fact that apparently this was something that people were well aware of in the community, and this letter does indicate maybe some type of proposal. So I guess one could say that would be a contractual matter, but I suppose that would fall more under subsection 3 than subsection 4. So I don't know if anybody else has any other thoughts about this.
Well, to begin with, having, read the submissions, and particularly the memo prepared by the state's attorney Wendt, I was leaning to believe that a violation of the executive session rules existed. But now I'm kind of changing my mind on that. Subsection 8, talks about information pertaining to the protection of the public or private property and any person on or within public or private property. And that's a statement. And then it doesn't say limited to A through G. It just says including A through G, which kind of modifies it, but I think it is not limited to those things. From just the plain reading of 8, clearly they discussed information pertaining to the protection of the public or private property. If you go to the different subdivisions there, I think it clearly could fall within emergency management and response. They had an emergency situation. They met to discuss the response, and which was the emergency contract for repairs, which was their response. They could have done other things, closed the building, or done other things of that nature. But I think if you just read the language of the statute, it falls within B. And I also think it, particularly pertaining to Exhibit 7, I think potentially falls within B as well, because it does discuss building plan infrastructure regarding that building or facility. So I think that there are some specific subsections that it falls into, even beyond the general exception in 8. Now, what gets me is I don't understand why this couldn't have been discussed in open session. I think disclosure of that information, what their response was something the public should have been made aware of and hear. But the analysis doesn't end there. If the statute allows them or affords them the opportunity to go into executive session to discuss certain subject matter, then they can, regardless of how I feel. Those are my thoughts.
This is Kate Hoffman. I was going to touch on a couple of things from both of you that you had discussed. First, I think it's important to keep in mind that although we do want things open and out in the public, the executive session isn't a shall, it's a may. So much like what Mr. Riedstrom was saying, this is something that perhaps could have been disclosed to the public, especially if they were already aware of some of the issues that were going on with the HVAC system. But I do believe that executive session with the may language in this subsection, I'm inclined to believe that it fits and it was appropriate here. I think they're reading just subsection 8 pertaining to the protection of public property and any person on or within that, and then subsection B, the emergency management or response. I'm also, like Ms. Tracy, inclined to think along the lines of what an emergency manager does at a county level that we deal with on a regular basis, but I think an argument can be made as to this situation itself being emergent. I guess I would just point out the fact that the letter was received on December 14 and the meeting was held on December 16. So to me, that I don't know what was well aware or made aware to the public, but I think that a letter dated 2 days prior and the information contained in the letter to me does seem emergent, something that needs to be brought up. And I think that that subsection could be read to include that reason.
Well, I think we've heard from all of the commissioners now on this, there being 3, considering this. Does anybody else have any response to this? I mean, meaning commissioners, any follow-up? Okay, with that, I would entertain a motion.
This is Alexis. You two have swayed me. So I would move that there has not been a violation of the open meetings law pursuant to the exception in 125.2 subsection 6, incorporating 127 1.5 subsection 8.
Do we have a second on that motion?
I would second that motion.
Okay. Stephen, we've had a motion and a second that there has not been a violation of the open meetings laws, and I would ask for a roll.
Yes, sir. Ms. Hoffman?
Aye.
Ms. Sobel is absent. Ms. Tracy?
Aye.
Ms. Wendt has recused herself and will abstain. Mr. Riedstrom?
I vote aye.
That's a unanimous vote amongst the 3 of you. Motion has passed.
That would conclude the matter, and we will move on to the next item in our agenda, which is 4C, in the matter of the open meetings complaint 20-03, Yankton County Commission. I understand that oral presentations will be made by the complainant, Todd Wood. And who will be presenting on behalf of Yankton County Commission?
This is Deputy State's Attorney for Yankton County.
Okay, what was your name again?
Deb Lilly.
Okay. Again, the rules are that each party gets 15 minutes for their oral presentation. A portion of that time may be reserved for rebuttal. Mr. Woods, are you reserving any portion of your time for rebuttal?
Yes, please.
Okay, how much would you like?
I would assume my presentation will be about 7-8 minutes, so the remaining time would be great.
Okay.
I may not use it all.
All right, very good. You may begin.
Mr. Chair, this is Alexis. If
yes,
I might,
Alexis?
I just feel compelled to note for the parties that I believe that this matter had originally been referred to me in my capacity as state's attorney as a potential conflict attorney. And I would just note for the parties, I don't feel that I have a conflict in sitting on the open meetings proceeding here. In light of that, I had received some information. I didn't have time to review it and ultimately responded to the Yankton County State's Attorney's Office to the same that they should probably find someone else to review it because I just didn't have the time when it was submitted to me. But I wanted the parties to be aware if either of them feel as though they would prefer I recuse myself from this, I sure can. I don't feel that I have a conflict.
Does either party have an objection?
This is Todd Woods. I guess my only question is, did you review any of the material at all?
There was a cursory opening of some documents that were submitted via email, and I think that they were in the nature of some of these minutes, but I can't even recall beyond the issues just sounded familiar to me, particularly agenda item number 2. And so I don't recall that, but I did receive some information previously.
I don't have an objection.
Ms. Lilly, do you have any objection?
No, I have no objection.
Okay. Go ahead, Todd.
Thank you, Commissioners, for your time today. My name is Todd Woods, and I'm not an attorney, but as a former County Commission Chairman, I brought forward my concerns on these matters. I want to start by referencing the 2015 A Guide to South Dakota Open Meeting Laws, which was published by the South Dakota Newspaper Association. And I quote, "South Dakota's open meeting laws embodies the principle that the public is entitled to the greatest possible information about public affairs and is intended to encourage public participation in government. South Dakota Codified Law 1-25-1 requires that official meetings of public bodies must be public and notice is to be given of such meeting 24 hours in advance of the meetings," end quote. It also, at the end of that paragraph, it states, "Openness in government is encouraged." So based on that, I want to just start with the alleged violation number 1. The published agenda, including the packet that was available online for the Yankton County Commission meeting October 1st, 2019, gave no mention or notice of item 11A and the resolution that was approved, resolution YC 19-8, which was added at the beginning of the meeting at the request of State's Attorney Clemish. This resolution was to approve an agreement or contract with the Minnehaha County Mental Illness Board. This resolution was not in the online packet, nor was an agenda item. And even in State's Attorney Clemish's response to the complaint that this was a continued item from September 18th, 2019 meeting. In his attached exhibit number 2, the approved minutes of that meeting, the minutes state, item will be rescheduled for a later meeting. There was no date listed in the minutes for the September 18, 2019. I'll move on. There's a lot of background noise. Am I being heard okay?
Yeah, I can hear you. This is Reedstrom.
Okay. I'll continue on. Alleged violation number 2 and 3, I'll combine into one comment. The published agenda item for that evening was for item number 12, simply states, appoint acting zoning administrator. It contained no additional explanation or any information in the packet that was provided, and it appeared to be a very simple and straightforward agenda item. I don't believe that was the case. Again, I referenced the Guide to South Dakota Open Meeting Laws and quote, what does the term sovereign power mean? The open meeting laws does not define this term, but it generally means the power to levy taxes, impose penalties, make special assessments, create ordinances, abate nuances, regulate the conduct of others, and perform other traditional government functions, end quote. The motion to appoint acting zoning administrator Jessica Atkinson included the delegation of power and authority to the Planning and Zoning Commission on enforcement of zoning, along with the appointment of Commissioner Healy as an advisor, were not published agenda items. The Commission, I agree, has the authority to delegate and grant sovereign power, but is required to give proper notice to the public for input. The published agenda and packet available online gave no additional insight or information to the public for that transfer of powers were going to transpire that evening. It's the burden of the governing body to ensure that the public is informed on all matters when granting or transferring power and authority. I again reference and restate the South Dakota Guide to Open Meeting Laws. The public, and I quote, the public is entitled to the greatest possible information about public affairs, end quote. The public and the people should not have to read between the lines or make assumptions of what is going to transpire at a meeting. Furthermore, as State's Attorney Clemish's response to my complaint, I refer to his page 4 at the end of the second to last sentence where it quotes, render decisions. This is a transfer of power and authority from one entity to another, and in my opinion, should have been disclosed on the published agenda. The transfer of sovereign power should not be disregarded or taken lightly and should be fully disclosed to the public before any transfer happens. I'd also like to point out, following this October 1st, 2019 County Commission meeting, there was a special Yankton County Planning and Zoning Commission meeting, which was held on Friday, October 4th, 2019 at 6 p.m. to exercise this new authority on selected zoning violations. This was held ahead of their normally scheduled Planning and Zoning Commission on Tuesday, October 8th, just 4 days prior. That meeting was also held on October 8th. My question was why the rush for an additional meeting and to utilize these new powers? The special meeting resulted in the revocation of several conditional use and building permits for several permits on new hog barns. Many of the Planning and Zoning Commissioners commented at that special meeting that they did not receive their packet until that night of the meeting, which is also an obvious additional violation. These permit holders appealed this decision to Circuit Court, costing them additional legal fees, as well as the county, along with increased construction costs and lost revenue. Recently, on October 16, 2020, a joint settlement was reached between the holders of the hog barn permits in Yankton County, agreeing these actions were improper and the permits were and are valid. In addition to the legal expenses, the county agreed to pay $10,000 settlement, which of course are tax dollars. On 9/18/2020, the county entered into an additional joint settlement agreement with another owner of the multiple hog barn permits, which deemed the county's actions were also illegal and the permits were and are valid. I mention this because if proper notice had been given on October 1st, 2019 agenda, the public would have been able to have an opportunity to have their voice heard. This could have avoided wasting taxpayers' dollars in litigation, settlements, and increased insurance deductibles and premiums. It also delayed the farmers from profiting on legal permits and not need them wasting dollars on attorney fees. When proper legal procedures are not followed, this opens up the county to litigation, costing tax dollars. I addressed each violation in the county commission, allowing them an opportunity to correct their action on November 5th, 2019, and was mocked for bringing this to their attention. In fact, Commissioner Healy said, and I quote, "You were only one person," end quote, dismissing my concerns. State's Attorney Clemish at that meeting admitted to 11A was not a published agenda item, but was continued indefinitely from a previous meeting. I will close with a quote from case law Olson versus Cass, which was part of a presentation I attended from Assistant Attorney General Steve Blair during the county elected officials training on the purpose of open meeting laws. I quote, "To protect actions being taken at secret meetings where it is impossible for the interested public to become fully informed and to detect improper influences," end quote. The burden lies solely on elected officials to provide all information for any open meeting where they are taking action. Failure to fully disclose these items discourages the public to interact only with government and shows a lack of transparency. That is the end of my comments. I would like to reserve the remaining time for rebuttal. Thank you for your time.
Yes, Mr. Woods, you have 7.5 minutes remaining for rebuttal.
Thank you.
Do any of the commission members have any questions that they would like to ask Mr. Woods at this time? Miss Lilly, I believe it's your turn. Your response. You have 15 minutes.
Thank you, Commissioners. Just to begin, I would like to say that the state submitted a response to Mr. Wood's open commission violations, and I will address specifically what we responded to. I was not at these meetings, and I reviewed the video. We obviously submitted that as an exhibit, and I don't know if the commissioners viewed the entire county commission meeting that reference, but the that Mr. Woods does reference make no mention of a commission meeting held later on a different date. I'm not aware of it regarding that planning.
This is Alexis, and I'm having some trouble hearing. It seems to be cutting in and out a little bit.
Okay, I'm going to try not speaker. We have trouble in our office with the speaker. Is this better?
Yes, thank you.
Okay, you're welcome. So I will address all of the allegations that Mr. Woods has in his open meeting complaint. As I was saying, there was no mention of a planning commission meeting or any allegations related to that. I was obviously not there, and I've not reviewed anything in reference to that, so I will not be addressing any of those arguments, and I don't think they're properly before the commission at this time. We submitted, as I said before, a response to the matter of an open meeting complaint in reference specifically to an October 1st, 2019 Yankton County Commission meeting. Mr. Wood cited 3 reasons for review. The first was that they added item 11A to approve a resolution. Prior to the approval of the agenda, Mr. Clemish realized that was not on there, so they added it prior to approval of the final agenda. The item itself was for an appointment of the Yankton County Mental Illness Board to also serve as the Mental Health Board for Lincoln County. That was due to the destruction of and the damage to the Avera Behavioral Health in Sioux Falls because of a tornado. As we referenced in our response, that agenda item had been noticed for approval on the September 18th County Commission meeting. Because the documentation was not done at that time, it was moved and it was to be rescheduled for a later meeting. Because of the timing of the receipt of the actual resolution to be approved, it was not included. It was added prior to the final approval of the agenda, and the County Commission basically didn't need any action or discussion or any input, as this was just a resolution that they were asked to approve so that the Yankton Mental Illness Board could act as the Lincoln County Board for mental illness hearings. As far as the other 2 allegations, we combined those into one response. The agenda item that was listed was to appoint an acting zoning administrator, and there was a motion that was made to do that. This was in reference to termination of the current zoning administrator, so they were going to appoint an acting zoning administrator. As the discussions, and if you watch the video, you'll see how it transpired. Basically, the proposed acting zoning administrator had concerns about her ability to handle all of the questions that were coming into her office, and as the meeting goes on, there was a suggestion or a request to maybe have a commissioner, in this case Commissioner Healy, to help review and assist in day-to-day routine matters and any complex zoning issues. And then, again, as the video continues, there was discussion about what, if anything, the Planning Commission itself would do. And so it is the position of the commission that the notice was given that they were going to appoint an acting zoning administrator. What specifically that acting zoning administrator's duties would be developed during the meeting itself, and any of the additional appointments were still pursuant to the notice that was given in the published agenda that the public had prior to the meeting. And at this point, I have nothing further unless any of the commissioners have any questions.
Miss Lilly, you have 8 minutes and 45 seconds remaining on your time, so we'll reserve that for you.
Sure.
In rebuttal. I don't have any questions. This is Commissioner Riedstrom.
This is Alexis. Ms. Lilly, was there a planning and zoning administrator previous to this meeting? Had there been a planning and zoning administrator?
There had been, and my understanding was that he was no longer employed by the county, so they were in a position, I believe they'd been using District 3 for some assistance because they did not have anyone in that position at the time.
So then the duties of the planning and zoning administrator would have been previously articulated and laid out in the decision to put in place a planning and zoning administrator.
I believe there was a description of what those duties would be, and as the commission meeting continued, there was discussion about the fact that the individual who was willing to accept the position was not comfortable and was not in a position to handle all of those duties. So the idea was to give her assistance during the time between when she was appointed and then when they actually hired the current zoning administrator.
Any other questions of Ms. Lilly? If not, then I will continue on with Mr. Woods. Just give me a second here. Okay, you have 7 minutes and 35, or 7 minutes, 7.5 minutes for rebuttal, starting now.
Thank you, Mr. Chair. I will first address, and I won't need all the 7.5 minutes. As Ms. Lilly stated, 11A was added for approval at the beginning because State Attorney Clemish did not have the documents ahead of time, and then added it at that meeting for the resolution. And as you look at the October 1st meeting minutes, the resolution is included in there. My comment with that to that would be if you knew it was coming, you can add it to the agenda ahead of time to be proper and do proper notice. And if the document didn't show up in a timely manner, then that item could be removed from the agenda. If there needs to be a special meeting, then that could have happened during proper notice a few days later to accept that resolution. Then going on to items 2 and 3, Commissioner Healy being appointed as an advisor, Commissioner Healy was already and continues to serve as a planning and zoning commissioner as appointed from the planning and zoning, as appointed from the county commission. As Ms. Lilly stated twice, The duties developed during that meeting that Jessica was unable to handle those duties, so they delegated that to the Planning and Zoning Commission. To me, that admits that the information wasn't all available to the public, because at that time the county commissioners didn't know that they were going to be changing the duties. So when they transferred power, it should have been delayed for another 2 weeks. And then finally, I will say the Planning and Zoning Commission, I only mention those violations as, I don't enter them in as a complaint, but I'm just showing that there was additional issues later on, and there seems to be a track record of lack of transparency and notice to the public. That is all I have.
Thank you, Mr. Woods. Do any of the commission members have any questions?
This is Cassie Wendt, and I have a question for Mr. Woods, if I may.
Yes.
Mr. Woods,
Yes.
You indicated that 11A was added to the agenda prior to the commission meeting starting, correct?
I'll clarify. It was added before the agenda was accepted in the meeting.
So it was prior to adoption of the agenda, correct?
That is correct.
And you have quoted for us today a guide to South Dakota's open meeting laws, correct?
That is correct.
Will you turn with me to page 4 of that document if you have it with you?
Give me 1 minute to open that up. I'm on page 4.
And for those who don't have it, first bold-headed paragraph talks about the agenda items to be considered if they are added less than 24 hours before a meeting. And it talks about that the public body adopts the final agenda upon convening the meeting. At this time, the governing body may add or delete agenda items and may also change. So when we talk about a new agenda item being added prior to the adoption of the agenda on that day, it was done pursuant to, would you agree, the Guide to South Dakota Open Meetings Laws, correct?
You did break up a little bit there, so I didn't hear all your comments.
Do you agree with me that the commission has the right under the Open Meetings Laws to add agenda items prior to adopting the agenda?
I do. Okay. But I also, my understanding is if you add an agenda item, you cannot take action on that agenda item unless it's published 24 hours in advance.
And then with respect to I have no further questions. That's the only question I had.
Ms. Wendt, this is Commissioner Riedstrom, or Chair. That ability to add items to an agenda before final approval of the agenda was the very issue in that Molden versus Grant Dual School District decision, which I was familiar with. Judge Tim decided that, and it was affirmed by the Supreme Court, and it became, the law that items can be added and acted on before the final agenda is approved. So I think that controls the issue as to item number 1.
And this again, and if I read the case correctly, it allowed, and I think you covered it, but I just want to make it clear, that case allowed not only for the addition, but for the act upon the things added during the course of that same meeting, correct? Was that your understanding?
It was.
Commissioners, can I make a comment?
Go ahead.
I do see that in the handbook. This is Todd Woods. I'm sorry.
Okay, excuse me.
I do see that as the commissioner was referring to, but to me, that opens a Pandora's box for elected officials to add anything to an agenda. I see that on there it says the public bodies are strongly encouraged to provide 24 hours notice. But if this is the case, you could have public bodies adding items to the agenda with no prior notice, which would greatly affect the open meeting laws and the transparency and, as it states, the encouragement of the public in open government. So I just want to make that statement.
Mr. Woods, this is Chair Riedstrom. That your comments were comments that were also of concern to prior members of the Open Meetings Commission in the past, and we've had discussions on that topic before, and you know, some members of the commission weren't entirely favorable to the decision that Judge Tim made, and the decision that was affirmed in the Supreme Court, but it was, and therefore that became the control. And so I appreciate your concerns, and I think that they're well founded.
Thank you.
Let's move on to anybody have any further questions as to agenda item number 12, the issue regarding the agenda item, appoint acting zoning administrator? If not, then I think we'll allow Miss Lilly any time. I believe she has 8 minutes and 45 seconds left in her rebuttal. Miss Lilly, do you have any further oral presentation to make, or rebuttal?
Thank you. Not very much. I mean, as far as Agenda 11A, that was Mr. Clemish's belief when he added it. He added it before the final approval. It was previously listed on the meeting agenda from the previous meeting, and it was a resolution that really, it required no board action necessarily other than to just accept it. And again, I just stand by what we put in our response to Mr. Wood's complaint, including, you know, any of the video that just showed notice was given of their intent to appoint someone. The public was well aware of the fact that the Yankton County did not have a current zoning administrator, and so notice was given and the actions that the board took were appropriate. Thank you.
Thank you. That would conclude the oral presentation part. Did anybody have any questions regarding this Miss Lilly's position on this matter? Any questions for Miss Lilly? All right, hearing none, let's proceed into deliberations on this. I'll go first. This is Chair Riedstrom. I don't find any violation as to item number 1, which specifically added the item number 11A to the agenda. I think that was proper for the reasons that have been previously stated. Regarding item 2, or agenda item 12, I understand Mr. Wood's position. The agenda item 12 just states appoint acting zoning administrator, which is one action, okay? And the public reading that, you know, would be advised that that's, you know, what the topic was, and maybe nothing more. But the board went further, and they actually took 3 actions. You know, appointing some supervisory control to Commissioner Healy on building permits, cups and variance applications, and to appoint the Planning and Zoning Commission to review any and all complaints that are received. So it seems like there were 3 things that they did when on the agenda it looked like they were going to do 1. Now, having said that, there is nothing in that I could find in 1-25 that speaks to how specific an agenda item has to be. And are we going to require those who prepare agendas to list any conceivable action that may be taken upon a certain subject, or is it sufficient to just generally state what the topic is going to be and let the discussions that happen during that when that agenda item is discussed to take place?
Mr. Riedstrom, can I respond to that?
Yes.
This is Cassie Wendt, and I did a handful of research on that exact question to determine what the purpose of the agenda is and where we get any of our definition about the contents. And what I found was there are several states that require that an agenda set out very specifically each action that is going to take place at the time of a meeting. And as you saw in the South Dakota statutes, which you discussed, we don't have a statute that clearly sets out the requirements of an agenda. And so as I continued my research, what I found, or what I believe is controlling, is that the purpose of an agenda is to provide the bare identification of itemized matters. And based on my research, and I use an Open Meetings Law 3rd edition written by Anne Schwing, together with my review of the South Dakota statutes and Dakota case law, I believe that the only requirement that our state has is for that bare itemization. And where it was provided that they were going to talk about the appointment of the zoning administrator based upon my review, I believe that they could talk about and make decisions about any and all items that relate to that discussion. That's my position.
Yeah, and this is Commissioner Riedstrom. I don't disagree with that at all. I think that when you put an agenda item on there, it's in my experience, it's always been a general. It's a heading, and in this particular case, when we're talking about the appointment of someone to a particular position in government, it just seems necessarily connected to that there also be a discussion about what that person's duties or responsibilities would be. And, you would assume that there would be a discussion about that. And so I think perhaps adequate notice was given to the public in this agenda. Any other comments or deliberations? Hearing none, I'll entertain a motion.
This is Cassie Wendt. I would make a motion for a finding that no violation occurred based upon the fact that the agenda was amended pursuant to statutory authority and case law, and that all of the discussions included in agenda item 12 were pertaining to the properly noticed appointment of the zoning administrator.
Do we have a second on that motion?
Second, Kate Hoffman.
Mr. Blair, there's been a motion and a second. With that, I'd ask you for a roll call vote.
Ms. Hoffman?
Aye.
Ms. Tracy?
Aye.
Ms. Wendt,
Aye.
Mr. Riedstrom.
Aye.
That motion passes unanimously.
Okay. That concludes this matter. Thank you all for participating. It was a very good discussion of some important issues. Thank you. We will proceed with our agenda. To item 4D, in the matter of the open meetings complaint 20-04, Pierre City Commission. It's my understanding that the complainant, Caleb Gilkerson, is that right? Will be presenting on behalf of the complainant. And who's presenting for the city of Pierre?
Lindsay Ryder-Rapp. I'm the city attorney for the city of Pierre.
Could you say your last name again? Ryder?
Ryder-Rapp.
Thank you. We'll begin with the oral presentation from Caleb Gilkerson. Again, a portion of the 15 minutes may be reserved for rebuttal. Mr. Gilkerson, are you there?
Mr. Chairman, this is Steve Blair. I did receive an email while we were proceeding through prior matters from Mr. Gilkerson saying that he was ill, and he asked if this matter could be rescheduled. I had responded that if he was unable to proceed because of illness, that was understandable, but rescheduling would put this out several months, and I asked for him to respond and tell me whether he wanted to reschedule or proceed, and I have not heard from him via email. And if Mr. Gilkerson is not on the call, I would assume it's because he's still too ill to proceed.
Well, it's my inclination to proceed. There's been a lot of material submitted in this, and I think that the issues are set forth fairly clearly. What are the other council or commission members? What's your position on a continuance of this matter?
This is Alexis. What type of notice did he provide, and did he provide any supporting documentation, Steve?
He provided an email about an hour and 20 minutes ago, and I didn't respond to it right away as I was following the proceedings, but I did respond about an hour, maybe a little less than an hour ago, with what I had previously relayed regarding, if you're too ill to respond to move forward, let me know. Otherwise, rescheduling is going to take several months. And that was the amount of notice. There was no documentation. And I have not heard by email from him or phone from him regarding that conversation.
This is Cassie Wendt, and I would argue that the notice of hearing indicated that we were going to start the oral presentations at 9:30 a.m., and that included the Pierre City Commission Hughes County complaint. And based upon what sounds like a notice or a request for a continuance that occurred at the time that this meeting was to start, I would ask that I think we do have enough information to consider based upon the written submissions, and I would ask that we move forward.
I concur. Go ahead.
This is Alexis. I would agree as well, given when the notice and lack of follow-up was provided, and so I think that that's appropriate.
Well, then we'll proceed, and we'll proceed with the Pierre City Attorney, Ms. Ryder, Rep. You have 15 minutes. You may proceed.
Thank you, Mr. Chairman. And I have you on speakerphone, so please let me know if it's echoing at all. I want to just first start by saying I'm the city attorney for the city of Pierre. I certainly appreciate the opportunity to come before you this morning. Let me start by saying that obviously the city of Pierre does not take these allegations lightly. The city certainly strives to ensure that our public receives proper notice of its meetings. It certainly understands the importance of an open, honest, and transparent process. Mr. Gilkerson had raised some concerns in an additional email that was sent to the commission. I believe all the commission members received that. I do not intend to address those allegations, but instead focus on the allegations as it relates specifically to the April 7th meeting. The city of Pierre's procedure for providing notice of its meetings is threefold, and obviously that's set forth in statute. First, the city of Pierre posts its agenda at City Hall the 24 hours prior to the commission meeting, as is required by statute. Secondly, the city always emails the city of Pierre employees as well as all of our media contacts. And we don't do this just for special or rescheduled meetings, but we do it for all of our regularly scheduled meetings that are held every Tuesday night at 5:30. And then lastly, the agenda is in fact posted on the cityofpierre.org website as is required by statute. Specifically as it relates to the April 7th, 2020 meeting, the city did follow its normal operating procedure by posting a physical copy of the agenda at City Hall. I think there was some reference perhaps in the police report that Mr. Gilkerson had alleged that we didn't do that, but there was no finding by the state's attorney that the city didn't do that. And then secondarily, and I think I did provide a copy of the email that the city sent to the local media contacts to advise them of the meeting. And then finally, the city of Pierre did attempt to post the agenda online or on our city website. And specifically as it relates to that particular issue, as I indicated in my response, and I don't mean to be redundant, but the city did make effort to post the agenda on its website 24 hours in advance of the meeting. Unfortunately, there was a technical error that occurred in the posting, and as a result, the agenda posted in draft form only, but it wasn't in fact published on the city's website, and hence, the city did not realize that until it was approached the following day, and at that time it did immediately post it to the website in order to ensure that there had been notification to the public relative to that. As indicated, the city obviously takes these allegations very seriously, and we've made effort to prevent an issue of this nature occurring in the future. And we've taken the following steps to address that. We've worked extensively, frankly, with our website host provider, Civic Plus, to investigate the error and to correct any issues with our website. I have a series of emails. I did not include those because there's lots of emails back and forth between the city and the website provider relative to some of the speed issues that we were experiencing and efforts to try to remediate that. We've also made sure that in the future, or now, I guess, that we've changed our internal processes. So now we use a website-generated confirmation notification to confirm that it's been published on our website. And then at that time, we then email the media. So we've taken steps to ensure that we get notification from our website provider that in fact the agenda has been published on the website and not just posted. And then we've also started to implement procedures of trying to ensure that we post the agenda as early in the day as possible in order to ensure that it is published by 5:30. I would just note, and I have read some of the Open Meetings Commission, discussions on issues of this nature. I would note specifically as it relates to the issue governing the qualifications of Mr. Gilkerson as a mayoral candidate. I don't want to get into all of the details relative to that because there's frankly a lot to it. Mr. Gilkerson had a hearing the week prior and at that time didn't have an attorney and so requested that he have a brief continuance to allow him to retain an attorney. The following week, which was the April 7th meeting that is at issue, his attorney received notice of the meeting on April 2nd. And so his attorney received notification the week prior that the issue as it related to him and his run for mayor, that issue would be considered on April 7th. So he did receive actual notice of it. I realize that the open meetings laws are not just intended to address a specific person, but the public at large. But I did think it was worth noting that he did receive notification. As I indicated, at the time of the April 7th hearing, he did not allege that he had not received notice. And in fact, he actually appealed the decision by the city of Pierre, and in the appeal to circuit court, there was not an allegation that he did not receive due process. So specifically as it relates to Mr. Gilkerson himself, he did receive actual notice at the hearing. And additionally, I would just note this issue was an issue that generated a lot of local media coverage. KCCR, one of our local media providers, did indicate online that the City Commission would be meeting that night and that one of the issues that they would be discussing was the mayoral qualifications of Mr. Gilkerson. There was also a lot of social media traffic that occurred relative to this particular issue. And I realized that that was not the only issue considered by the commission that evening. The situation obviously that occurred was inadvertent. It was unintentional. And in fact, it was really a technical error with a speed site issue in our website provider. The city of Pierre, like I indicated, has the threefold approach to notifying our citizens of the issues that they will discuss during our regular city commission meetings. We have a consistent time and location of our meetings. They're every Tuesday night at 5:30. As I indicated, we provide that information to our media provider to ensure that they are able to get that information out into the public. Obviously in this particular circumstance, one of the layers of notification, unfortunately did not occur because of that technical error. But we certainly, make every effort to ensure that the public has, knowledge relative to our meetings. And we're fully committed to complying with our obligations under state statute. And as I've indicated, we've implemented measures to ensure that issues of this nature do not arise in the future and that the requirements of state statute are in fact met. Thank you, Mr. Chairman.
Thank you. I think that concludes the oral presentation portion as there will be no rebuttal here. So at this time, I'd ask if any of the other commissioners have any questions of the city attorney.
This is Alexis. Just wondering, you had mentioned that there was, and I just want to clarify, there was a draft of the agenda that was posted, but the final agenda didn't get posted within 24 hours?
Well, so it posted in draft form, but it wasn't published on our website, if that makes sense. So
could the public access and review the draft form?
No. And so our city finance officer, she posts it in draft form, but it doesn't publish. She has to press a button before it to be published. And what happened was it ended up spinning and spinning and spinning and spinning instead of publishing it like she had attempted to do. And she didn't realize that until the next day.
Okay, so she, for all practical purposes, was attempting compliance, but then didn't realize that difference in the steps.
Exactly.
Okay, thank you.
Yep.
Okay, this is Cassie Wendt, and I have one question following up. So, Lindsay, what I picture in my mind, and I'm not a computer person, but is that she clicked the right buttons to get the draft form posted. She clicked publish. The computer system simply did not publish it on the website. Is that correct, or did she miss a step?
Nope, you're exactly right. It just kicked it back. She attempted to post it on the website, but it didn't publish. Instead, it just sat there and spun, essentially.
So the city finance officer actually took every single step necessary to publish it on the web page. It's just the computer system didn't allow that to occur.
Correct. It kind of kicked it back. I mean, that's maybe not the best word for it. I'm not as computer literate as I maybe should be as well, but that's generally, I mean, that's what happened.
Thank you.
Lindsay, this is Reedstrom. What did you say the name of your web host was? The service that
Civic Plus.
And you indicated that you made contact with Civic Plus to determine what went wrong.
Yes, we
there's
a lot of emails.
What went wrong, according to them?
They don't know what went wrong. Unfortunately,
whatever went wrong
was. Yeah.
Is it fair to say that what went wrong was more on their end than on the auditor's end?
I mean,
or your finance officer?
Yeah, I mean, I would characterize it as a technical issue. Obviously, and I want to be careful with my words. I mean, obviously, the city finance officer, and she's now realized that she probably needs to post that way earlier in the day and constantly be vigilant about checking to make sure that it actually published. But on that particular occasion, she thought that it had published. She took the steps to post it on the website for all intents and purposes, thought it did, and then did not realize until the next day when she was approached.
Any further questions?
This is Alexis. But for all other purposes, the agenda was available in the office 24 hours in advance. Compliance was adhered to in every other respect?
Yes, that is correct.
Thank you.
I don't have any further questions from Commissioner Reedstrom. Should we move to deliberations? let me start. I believe everything the city attorney said is exactly true. I don't think the facts are disputed here in any way. I believe it was an inadvertent, unintentional technical error, and that they made every effort, to do what the statute required. That being said, the statute says that the notice shall be posted on the website 24 hours in advance of the meeting, and that didn't occur. So I believe there is a very, very technical violation of the open meeting statutes that was almost unavoidable on the part of the city of Pierre. I do believe they made every effort. I believe that they know and understand and respect the open meeting laws and make every effort to comply with those laws, and try to in this case. But due to the technical glitch or error, they weren't able to satisfy one of the requirements that the statutes say they must require. So I guess that's my position, that there is a very technical violation of 1-21-1.1.
This is Cassie Wendt, and I respectfully disagree. And when I read 125-1.1, when you look at the first couple of sentences, it talks 24 hours. It must be posted, a copy of the notice, visible to the public at the principal office, which we've learned today occurred. It also talks about sending that notice under that same sentence that talks about within 24 hours to the local news. It states the notice shall also be posted on the political subdivision's website upon dissemination of the notice. And I believe that the legislature knew how to make that requirement 24 hours because they did so just above. However, I don't believe that 24-hour notice applies to the publication or posting on the website. I believe that the time frame is different. It is upon dissemination as opposed to with 24 hours notice. And I don't know if that necessarily makes it different, but I just don't think that 24-hour time frame applies in the same manner as it does when, upon dissemination, the city finance officer took every step necessary to publish the information, and upon being advised it was not on the web page, immediately took those steps again to post it on the website. Like I said, I don't know that saves it from being a violation, but I don't think, based on the way the statute's written, that the posting on the political subdivision's website is 24 hours immediately preceding, as it is for the other locations where notice is given. I believe that the standard is different under that subsection or under that sentence.
This is Alexis Tracy. I don't know. I almost think by sending the notice on, I'm wondering if it would actually expand the time frame, because I think we'd get a little bit unwieldy if we read it to be a lesser time frame. Then I think it just becomes what's reasonable. But I struggle with this one more along the lines of, this feels more like a natural disaster or some unforeseen factor out of one's control. Had we heard information that this was an ongoing problem that the city constantly was aware of, they had issues with, or had failed to address a technical problem. But I'm wondering you know, and I'm just glancing through some things here myself. If there was any exceptions in regard to the pandemic response, I mean, this meeting would have occurred on April 7th, 2020. And when I think natural disaster and unforeseen circumstances, I'm thinking along those lines. I don't know if anyone else has any questions or comments, but, you know, the city attempted to adhere to this, and I'm struggling with the technical glitch being the problem, not human error.
This is Commissioner Riedstrom. I read the statute a little differently than Ms. Wendt. I think that the 24-hour notice applies to both the website and the dissemination of the notice to the other agencies and the posting of the notice in the courthouse or wherever the meeting's taking place. I think when you disseminate that information, you know, those have to be done 24 hours in advance, and that's the dissemination. And the posting on the website is, you know, upon dissemination of the notice, it shall be posted on the website if the website exists. Now I want to switch gears a little bit. We have a situation here where there was something wrong with the computer and something wrong with the website that didn't allow the notice to be posted. The city had no control over that. So does that mean that the website, because it wasn't working and it was incapable for some technical reason of accomplishing the task, does that mean that the website at that time didn't exist? I'm looking at this from a different perspective. Follow what I'm saying? If the website doesn't work, does it exist?
If it wasn't operable in the manner in which it was supposed to work?
Yes. Do you see where I'm going here?
Yes.
I don't know. I guess if the website itself existed, but it didn't do all the functions which it was there for. I mean, it wouldn't allow the notice to post. I don't know, just a different way of looking at it, I guess. I'm kind of torn on this one too, but I guess I'm still in my basic camp of thinking of a technical violation exists here. But I could be persuaded otherwise.
This is Kate Hoffman. I'm sort of floating in the same land that Mr. Riedstrom is. I interpret it as far as posting to the website in the same manner that he does, that it should be done within 24 hours. But then I also hinge on if there's absolutely no way to post it to the website and it wasn't functioning and there's confirmation of that, then can you allege that the website doesn't exist? And all of the other portions of 125 1.1 have been complied with. They haven't had continual issues with the website. This is sort of a fluke thing. So I guess I'm on the fence with maybe a very, very technical violation. But also I'd agree with Mr. Riedstrom that I could be persuaded otherwise too.
This is Commissioner Riedstrom again. You know, and the city attorney alluded to this, that because they became aware of this situation, they've instituted additional sort of remedial measures, including posting or attempting to post the agenda on the website much sooner or sooner than the 24 hours to make sure, that it did post, and maybe still have some time to address any technical issues and figure those out. But I am a little torn on this.
This is Alexis. Obviously, I am too. And I think going about if the website exists line of thinking, it's kind of that impossibility aspect of things. I just struggle with making a decision on this. I'll defer to those with more experience than me. Is there any way we can take this under some type of advisement or thoughts on this? Or do we need to make a decision today based upon the information before us?
Well, there's nothing to prevent us from taking it under advisement. I think that the parties involved would prefer that we make a decision rather than leaving this in limbo. And I also don't know whether any additional information or authority, would exist that would help resolve the matter. I think that this is a pretty novel circumstances if we're now focusing on kind of my theory about whether the website actually exists or not when it malfunctions.
So I did just some quick Googling. This is Cassie Wendt. When you look at the definition of exist, one of those definitions is to continue to be. And that's where I'm at. I find it very hard. Like I said, I'm not a technical person. I'm not good at computers. I find it very hard to find that a city finance officer who literally took every step necessary, only the computer side of things didn't work, is in the wrong. I mean, that's where I'm having a hard time. And so, I mean, I think that there is a strong argument that if the website wasn't accessible in the way it was in the past, reads from maybe it didn't exist because it was not accessible to the city finance officer.
But we don't think that the website was actually down, though, right? Like if a citizen went to the website, everything else was going to be up and operational and working, right?
Right.
Right. They just weren't able to add additional information to it at that time.
And the thing about it is, the reasons for these notice requirements and, including the website now is because we live in that kind of a world. And people go to the internet and go to these websites many times to find out, to look at the agenda and see what's going to be discussed, rather than, putting your boots on and marching down to the courthouse and looking at the window. It is a medium out there that people use, and in this case, those who access the website, didn't find the agenda, and thus weren't adequately informed about what was going to be taking place at the meeting. I find that. Yeah, go ahead.
Sorry. This is Alexis. I'm just thinking along the lines, too, of I don't know the answer to this. I don't know if it would have been remedied if she then went out and checked to make sure it's posted or something in that regard. I'm thinking along the lines of an attempt to file something with the court system and any obligation of follow-up to make sure that that was properly filed, or is submission enough? Whose duty does it fall to ensure that compliance?
Well, the duty falls upon the public body to follow the requirements.
And do you guys interpret it to be then that had the city employee who was attempting to post it checked the website, it would have become immediately apparent to her that it had not posted, and then she would have taken the additional steps to publish rather than just post the draft?
Yeah, I think that's entirely possible. I mean, the attempt was made, before the 24-hour period started, but the error wasn't discovered, until the following morning at 7? I can't remember the exact time, but I don't know.
And this is Alexis again. Did they? Was there a need for involvement with the tech company, or did one just have to go publish it? I mean, was it a human error, or was it a technical error?
Well, I think it probably could have been both. I think that you could say that it was a technical error because something was wrong with the computer or the website, and it was partially human error for not, I guess, following up and making sure that it did actually post while there was still time to do that. And then maybe afford yourself the opportunity to get it remediated within the time frame.
And this is Alexis. I think that's consistent with, so I'm looking at the response here from the letter from the City of Pierre dated September 30th, 2020. And 4 paragraphs down, it does say, although city staff followed normal processes to post the agenda online, it did not become visible for public viewing. Upon realization that a system error had occurred, staff immediately made a second attempt to post the agenda online. The effort was successful, and the agenda was publicly posted at 9:30 a.m. on April 7th. So, to that end, I'm actually becoming a little more swayed that this is a technical error or a technical violation, certainly not bad faith, certainly not bad intent, but an error nonetheless, that had there just been that follow-up to review it the night that it, the time that it was tried to be posted the first time, that may have been remedied, and not necessarily an issue with the website being down or inoperable.
This is Kate Hoffman. I think I'm inclined to agree with Alexis. It doesn't sound like, based on that response, that there was any requirement to get the computer software people involved to get it. It sounds like once it was noticed, it was the employee was able to do it then right there.
This is Cassie Went, and I don't disagree. I agree with your position.
Well, I think that it may be time for a motion. I'd entertain a motion.
This is Cassie Went. I would make a motion for a finding that a technical violation occurred based upon the lack of posting on the website within 24 hours of the meeting.
Do we have a second on that?
I'd second that, Kate Hoffman.
I think there needs to be two parts to the motion, though. Does the motion include the reprimand? I think it has to.
I'm fine with that. That can be added to my motion. I will support that.
Okay. Stephen, are you all right with that?
Yeah, I am. I think that's appropriate.
Okay. And did I hear a second?
Yeah, Kate Hoffman, I would second that.
Okay. Stephen, would you give us the roll call?
I will, Mr. Chair. Before I do that, I was trying to find the statute that talks about the reprimand, and just for the record, 125.7 says that if the commission finds a violation, the commission shall issue a reprimand. So
yeah, that's
I think it's appropriate to include that language in the motion, but if you had not, I think the reprimand still issues. So with that, I'll call the roll. Ms. Hoffman?
Aye.
Ms. Tracy?
Aye.
Ms. Wendt?
Aye.
Mr. Riedstrom?
Chair votes aye.
That motion passes unanimously.
Thank you for everybody that was participating, and that was very interesting subject.
Thank you for the discussion. I appreciate it as well, and we'll certainly do whatever we can here in the future to ensure that doesn't happen again. So thank you very much.
And Ms. Ryder, this is Cassie Wendt. I do appreciate all of the information that you provided us about what steps the city took to remedy that issue. I think that's very, very positive as well. I just wanted to say that.
Thank you very much. I appreciate that.
This is Alexis,
Thank
and
you.
I would agree. It's something interesting to take back to our own boards, I think.
Well, let's continue on then with the agenda. Item 5 is a discussion regarding preparation of the minutes. Steve, I'd probably turn the floor over to you on that.
Thank you, Mr. Chairman. And we put this on the agenda, Ms. McFarland and I did, basically to discuss the preparation of the minutes due to the fact that we have so many new members on the commission. One, to give an update how the minutes are drafted and the form that they're drafted in currently, and also to make sure the commission members still want to proceed with the way we do it. So currently we draft very detailed minutes, and statute requires those to be posted within 10 business days of the meeting. And as you can imagine, some of them are then very lengthy. In the past, the commission had determined that they preferred very lengthy minutes, almost to serve in lieu of a transcript, because oftentimes there is a delay between hearings and when written findings and conclusions are adopted. And I guess I should step back that based on the decisions you made today, I will draft written findings and conclusions and submit those to you as well as copies to the parties. And then in a future meeting, you'll be asked to adopt those. And so previous iteration of the commission indicated that they preferred the lengthy minutes in order to refresh their memory about the hearings that had occurred and therefore make a decision on the findings and conclusions. We do have the ability to post audio of the meeting, and that then lists the 10-day requirement to post the written draft minutes. And that is also an option, and that's one of the things that we wanted to check with you on, whether you wanted us to post the audio in lieu of the minutes. We don't generally do a transcript of these hearings and meetings. We don't pay for a court reporter, but we do generally make an audio recording for purposes of ensuring the minutes are accurate. So with that, I wanted to present that information to you and just check with the commission members on how you would like us to proceed drafting the minutes, whether you wanted us to proceed with the current method of the long form minutes, or whether you wanted to direct us to post the audio and then at some later time prepare the draft minutes. Regardless, draft minutes will still need to be prepared. It's just a matter of that 10-day window to prepare the minutes and get them posted on the website.
Steve, I guess my position is to continue with the way we've been doing it. I think that's been working for us. Let me ask you directly, how would you prefer doing that? Would it make it easier for your staff to just post the audio first and prepare the draft minutes later?
Yes, I think that would make it easier. I don't prepare the minutes, Ms. McFarland does, and I review them. And so, again, some of the lengthy meetings we've had, it's been quite a lift for her to get those prepared and then for me to review before those 10 business days passed. It's not impossible, but to answer your question, it would make it easier. But again, that entails posting the audio, and we don't have sophisticated audio equipment, just to be upfront. So the audio recording is oftentimes not crystal clear or the best recording either, just to make sure you have all the information available. But it would be easier on staff.
Just to get this straight again, Steve, if you post the audio of the meeting, then you don't have to comply with the filing the draft minutes in the 10-day working day period, because the audio takes the place of that.
That is correct, and I'm trying to find the statute. I apologize, I should have pulled it up before. So 127.1.17 requires the unapproved draft minutes of any meeting held pursuant to the open meeting statutes be available within 10 business days after the meeting. And then it goes on to say, however, this section does not apply if an audio or video recording of the meeting is available to the public on the governing body's website within 5 business days after the meeting. So it lists that 10 business day requirement if you post the audio, and then there's more time to prepare the written draft minutes that can then be prepared and provided at a later date.
And if you post the audio, then there's a 5-day requirement, did you say?
Yep, you have to post, if you're going to post the audio, you have to post it within 5 business days after the meeting.
Hopefully there's not a technical glitch.
I thought the same thing.
I would agree.
I don't know, what does everybody else think? I don't really have an opinion one way or the other on that. Either way is fine for me.
This is Cassie Wendt. I don't have a specific request or requirement. I just think the easiest way for the Attorney General's office is fine with me. I would rather it be something that they can time limit that would be tough for them to meet.
Especially, this is Reedstrom, especially since the meeting today was rather lengthy, and the minutes probably will be very lengthy as well. I know that
I'm in agreement
Ms.
with that.
McFarland does a really excellent job, preparing very detailed draft minutes.
So this is Alexis. I don't know if we need a motion or something in that regard contemplated. I would agree that whatever's easiest, but maybe, you know, if it's allowing for the audio to be posted within 5 days, and if for some reason that is unable to be accomplished, then a written detailed minutes to be posted within 10.
I agree.
In case there is a technical glitch or something to that effect.
And I don't think we need a motion on this because, you know, the law allows us to do it either way. I mean, do you agree with that, Steve? Or would you prefer that there be a motion?
No, I agree. There's no motion necessary. You're really giving direction on a discretionary item to your staff, which I don't think requires a motion.
Right. All right. We'll give you that discretion, and you know, if you want to post the audio tape, that's fine with the board, I believe.
Okay, thank you. We will proceed that way, posting the audio within 5 business days, and if for some reason that can't be done, we will post the written within 10 business days to make sure we maintain compliance with the statute.
Very good. Let's move to item 6, discussion regarding potential open meetings legislation. Again, Steve, I'll kind of turn it over to you.
Thank you again, Mr. Chair. And this item was only put on the agenda to bring to the commission members' attention that legislative session will be approaching early next year in January. And if there are any potential changes to the open meetings laws that you have identified, to contact me as soon as possible. Those will need to go through a drafting and review process if we were to bring anything, and would probably need to be introduced by the Attorney General as an Attorney General bill, which would require us also then to reach out to a standing committee of the legislature and get their permission to bring the bill. And so there's a few steps involved. And so if there are any ideas that need to be looked at, as much lead time as possible on getting those accomplished would be appreciated. I can say I don't have any particular items that I've addressed that need emergent legislative fixes, but if anybody has any ideas out there, please contact me and we can discuss those.
All right, any further discussion on this item? All right, let's move on to item 7, election of commission chair and co-chair. And I'll just start that discussion. It can't be me because I didn't run for a 7th term, so my term as state's attorney will be up at the end of the year. So I will be leaving the Open Meetings Commission.
Are we allowed to nominate Ms. Stovall in her absence?
I think we'd be allowed to do that.
Well, this is Alexis. I would nominate her for chair then. I think that she has more experience than the rest of us, and as co-chair, right, she's currently our co-chair. I think that would be most appropriate.
I'd call for a motion on that.
I would move that she be chair for the coming year.
Do we have a second?
Went second.
Steve, I'll do a roll call vote.
Ms.
I'll
Hoffman?
ask you to.
Aye.
Ms. Tracy?
Aye.
Ms. Wendt?
Aye.
Mr. Riedstrom?
Aye.
That motion passes.
Okay. That brings us to item 8, scheduling future meetings.
Mr. Chair, you do need to, the commission last year determined to elect a chair and a co-chair.
Oh, excuse me. Did I skip that? I skipped that, didn't I? So we'll go back. Do we have a motion for a co-chair?
This is Cassie Went, and I would move to make Alexis Tracy the co-chair.
Do we have a second on that?
Kate Hoffman, second.
Mr. Blair?
Ms. Hoffman?
Aye.
Ms. Tracy?
I would abstain.
Ms. Wendt?
Aye.
Mr. Riedstrom?
Aye.
That motion passes with Ms. Tracy's abstention.
Okay. Item 8, scheduling future meetings. Stephen, do we want to schedule a meeting before the end of the year while I'm still on the commission to review the findings of fact and conclusions of law on the 4 matters that we discussed today?
I think that would probably be advisable for the reason you stated. We don't have any current pending complaints. And now that I said that, we'll probably get some, but we don't have any that I'm aware of right now. So it would be just to adopt the findings and conclusions from today.
Should we look at a time since we're all on the phone?
We can certainly do that.
Idea.
What kind of lead time do we need, Steve, on this? I'm thinking maybe in December.
Yeah, I'll need some time to prepare them and then get them out to the parties, and that can be done at the same time as the notice of hearing. We usually like to give a couple weeks or 20 days notice. So December is probably the most appropriate time.
I'll just throw out December 18th. How does that look? It should be a short meeting.
That is a circuit day for me in Turner County. Typically, we just handle stuff in the morning.
Anybody else have any suggestions?
I could be available. This is Cassie Went. I could be available December 18th in the afternoon if that works for everybody else.
It works for me.
This is Alexis. That would work for me as well. And I would just, Kate, would you like us to shoot for more of a mid-afternoon, or what are your thoughts on what's most reasonable?
Yeah, to be real honest, that's not one of our real true regular dates. Judge Knopf calls them float dates. So if we have stuff, we just kind of puts fillers in the morning, and he starts about 9. So I would say, 1 o'clock would be just fine if that worked, right after lunch.
That works for me.
That works for me. Is there anybody that doesn't work for?
This is Steve Blair. That works for me.
Does that give you enough time, Steve?
Yeah, that should be plenty of time.
Because the week following, is kind of Christmas, and I think some people take a lot of that week off. I think the 18th kind of works. So should we go with that? Do we need a motion on this, Steve?
No, you don't need a motion. I think that is acceptable to move forward that way. I will check with Ms. Sobel about her availability. Although since she wasn't here today, I'm searching my mind whether she can vote on those anyway. I'm not sure on that. I'll have to consider that. But I think that date works, seems like it works for everybody, and it will be adequate notice to the parties as well.
Okay. 1:00 p.m. All right. I think that concludes the agenda. Do we have a motion to adjourn?
Motion went.
Second?
Oh, this is Alexis, I'll second that.
I don't know that we need to do a roll call on a motion to adjourn, do we, Steve? Or should we anyway?
We should anyway. It's always a gray area.
Yeah.
Ms. Hoffman?
Aye.
Ms. Tracy?
Aye.
Ms. Wendt?
Aye.
Mr. Riedstrom?
Aye.
The motion passes.
Meeting adjourned. Thank you all for your participation. Appreciate the excellent discussions.
Thank you.
Thank you all. I hope you have a good rest of the day.
All right. Very good. Thank you.
Take care.
Yeah. Bye-bye.
Bye.